Good afternoon, everybody. Welcome to another Q&A session with yours truly, Chris Justice. I'm an employment lawyer with Samfiru Tumarkin. I work out of their Toronto office, and I am here today to answer hopefully as many questions as I can, all things employment related. I myself do a lot of work regarding wrongful dismissals, a lot of issues pertaining to human rights, and a whole host of other issues, whether it's going into the workplace during your tenure with your employer or on the exit. So do send your questions in. I know that the hot topic today, or recent days anyways, has been, of course, the ongoing pandemic and its effects on the workplace, whether it has to do with vaccinations or COVID policies, COVID layoffs. So certainly if you've got questions pertaining to that, definitely send your questions in. I wanted to start today just with a brief discussion regarding workplace stress. I know that, especially nowadays, a lot of individuals are experiencing stress within the workplace, and that stress could become a result of a number of factors or be linked with a number of factors, whether it be your employers adding a bunch of work onto your plate, or perhaps the reverse of that, your employer is taking a bunch of work off your plate, maybe reducing your pay, or you might just find yourself in a situation where you've got a boss who is harassing you, or there's some other example or instance of maybe a more toxic workplace environment that's applicable to your situation. So, whether it has to do with your employer subjecting you to a toxic workplace environment, or your employer changing around the scope of your job or reducing your pay in some way, just know that you as an employee have an option or a number of options at that point, and that it's always good to seek legal advice earlier rather than later regarding any of these issues, because the last thing you want is for someone to take the position that you've condoned the changes or that you've condoned the workplace environment in some way by remaining silent. And just know that you don't necessarily have to stay in that situation and kind of grind through it. That, again, you may have options, and those options could include you being entitled to potentially very significant forms of severance, as well as a number of other damages that could be related to bad faith allegations. So again, if you find yourself in a situation like this where you're under stress or your employer is changing things very drastically on you without your consent, definitely get in touch with a lawyer, and we'd be happy to help out to the extent we can. Otherwise, as it relates to stress, I think first and foremost, mental health is important. So you'll want to make sure that you understand what workplace benefits or policies are applicable. For example, to take a form of stress leave, or whether or not maybe you can apply through WSIB, depending on if you can connect your, impairment or disability to the workplace. Or potentially avail yourself of a workplace disability policy, whether it's short-term or long-term. But that's another thing you'll want to look into, just to secure yourself some benefits, and depending on the impact it's all having on you, hopefully get you back to a position where you can return at full strength. That said, I will get into some of the questions right now. And so I've got a question from Spencer on Facebook, and Spencer is asking, can an employer put you on unpaid time off for not getting vaccinated? And that's a good question, Spencer. It's very, of course, topical at the moment. And for the most part, an employer cannot put you on unpaid time off for refusing to get vaccinated. So if you're an employee and you find yourself in a situation where your employer is essentially imposing a layoff or a leave of absence on you, and especially if that means a reduction in earnings and you don't, again, consent to it, then that's something you'll want to definitely get in touch with us on, because that could trigger what's known as a constructive dismissal. and entitle you to potentially significant forms of severance, as well as additional benefits or compensation, perhaps for or further to bad faith allegations. So, Spencer, you'll definitely want to get in touch with us. We can get some further details from you and find out exactly what your options are and what kind of a case you could be looking at. So, thank you again for asking that question. I've got another question in here from JD on Facebook, and JD is asking, even hospitals with mandates. And I think JD is just referring to situations where a hospital employee is placed on a leave of absence, for example, without pay due to refusal to get vaccinated. And JD, I will say that even employees at hospitals with certain mandates in place, even those employees could easily be entitled to severance for the hospital's decision to place you on an unpaid leave of absence. So don't think that just because you work at a hospital and you've been placed on a leave for refusing to get vaccinated that you have no case. There are mandates in place. There are government pieces of government legislation and mandates in place with respect to certain industries, and hospitals are one of them. But just for that fact, don't assume that that means you have no case. And it's actually very, very rare that there's a mandate that applies to an industry that requires a vaccination and only a vaccination. I know that in a lot of industries with mandates in place, there is an option as to whether or not the individual is to be vaccinated or perhaps submit to testing. So even in these specific industries, there is still a good likelihood that you would be owed severance as a result of your employer's action to place you on an unpaid leave of absence. So again, get in touch with us if you need some further help, and I'm sure that we can flesh that out more for you. I've got a question, another one in from Valerie on Facebook, and Valerie is saying that she's got a doctor's note regarding a wait to see an immunologist, and is asking if they can still put her on an unpaid leave and if she would have a strong case to take the employer to court. So I think that in any situation where an employee has requested an exemption to be vaccinated, and that can mean from a religious standpoint, that can mean from a medical standpoint, I think that that can be a helpful thing potentially in building a stronger case against the employer, because it puts more of an onus on the employer to try to accommodate your situation. And if there are or is an instance where your employer can accommodate you, then as I said before, if anything, that would just give you more leverage to have a stronger case should they continue to insist that you can't work. So I think it's, again, helpful to get a doctor's note and submit that to your employer in support of your request for an exemption or perhaps a request to work from home. So definitely that can help. And in terms of how long it would take for you to get a settlement, Valerie, that's a difficult thing to say just because there are so many variables. It could be a matter of months, or it could potentially take over a year. It just simply depends on how your employer will respond potentially to a lawsuit, what you're exactly looking for, and obviously to what extent the courts are able to kind of expedite things. But in any case, we as a firm, we always look to advance matters as quickly, as expeditiously, as efficiently as possible. And at the end of the day, if you're potentially owed significant severance, I would say get in touch with us, and that shouldn't necessarily be a hindrance to you pursuing something, especially if those entitlements are quite significant. So maybe you want to contact us for a further consultation, Valerie, and we can get some more information from you. Denise on Facebook is saying that as of December 31st, her employer has given her an option to either get vaccinated or take a leave of absence with no pay. And Denise, I don't know if you caught my earlier comments, but don't think that you have to get vaccinated. And just because your employer puts you on a leave of absence with no pay don't also think that they can necessarily do that and get away with it. There's a very good chance that they would owe you severance. However, Denise, you raise one important point that I want to mention, and that has to do with the fact that your employer has given you notice, as far as saying to you, by the end of the year, you either have to get vaccinated or we're going to place you on a leave of absence. I think that for any employee who's being given notice ahead of time that they need to make a decision at a later date as far as whether they want to get vaccinated or not, it's better for that individual to get in touch with a lawyer sooner rather than later, and not wait for that end date, because there are going to be some circumstances where the company will be given some form of credit for the fact that they've given you the heads up. But it really does come down to exactly what they've communicated to you and how definitive they've said, what will happen as of December 31st. So, Denise, I would suggest you get in touch with us as well. We can flesh out some of the details of that and figure out to what extent the notice being given to you, whether that would actually matter or factor into a potential settlement. But again, don't feel as though you have to get vaccinated, of course. It's completely voluntary, and there's a good chance that you could be owed severance beyond the 31st if, in fact, your employer refuses to pay you at all from that point onward. So thank you, Denise, for your question. Life of Hope on YouTube is asking how much we charge for consultations. So if you're an individual and you've got a particular matter regarding COVID or anything employment related, it will depend on your specific case and specifically what facts apply to your case. We as a firm, we offer a lot of the time a free consultation, but depending on the information or the situation in your case, that may not be an option that we can afford to provide. So what I would say is get in touch with us. Let us know what your situation is all about. And at that point, we can better be in a position to tell you whether or not the consultation be done on a free basis or whether it would be based on an hourly rate or a discounted hourly rate. And that would also come down to which lawyer is assisting you in your case. So do follow up with us in any event, and we can definitely take it from there. I've got a number of other questions, so forgive me, everyone, if I can't get to yours, but I've got one in from Spencer on Facebook. And Spencer is saying that he's been on a temporary layoff since March of 2020. He's asking what he should do. And he's saying they told him they don't have anything for him yet in terms of work. So thanks for your question, Spencer. I think this is a good time to point out that if you're somebody who's been on a layoff or a leave of absence for quite a while, and maybe even dating back to the beginning of the pandemic, and especially if you're still in the dark or in limbo as far as what your employer's doing and you feel like maybe they're dragging things along, I would definitely highly recommend you get in touch with us. You don't want to wait any more longer than you need to, because for any of you that are on a layoff or on a leave of absence, the more time that passes, the potentially the more risky the case could become. So you want to take initiative quickly, or at least talk to a lawyer to get a better understanding of what your rights and entitlements are, because there could be a good chance that that lawyer is going to advise you to commence something sooner rather than later, so that you can hopefully get as good of an outcome or potentially a settlement package as possible, given the years of service and that kind of thing that you put into that company. So Spencer, get in touch with us, because it's better to act now rather than later. Jack on YouTube, he's asking how long it takes typically to negotiate a severance package or an improved severance package. And Jack, that's hard for me to answer specifically. It would depend on how complicated the case is. It would also depend on how much more money you're seeking. I would say that typically speaking, you can probably find out what the most an employer of yours is willing to offer, fairly soon. And then it just becomes, I think, a question of whether or not you ultimately accept that offer for whatever reason, or whether or not you have to commence a lawsuit to get something better, and if that's a recommended step. Because I think if you're talking about avoiding a lawsuit, it could take, a matter of weeks or just a couple months. But if you're talking a lawsuit, then you could be looking at several more months. So it would just depend. And if you have any question about that, you've mentioned already starting the process with our firm. I would just say contact the associate or the lawyer that's working with you, and they should be able to give you a rough idea as to what a timeline would look like and whether or not you have to commence a lawsuit or not. So thank you though for reaching out and asking, Jack. Again, forgive me, everyone. I'm just looking through some more questions. Andrea on YouTube has said that she has been working with someone for 21 years. She's on a disciplinary leave of absence. I don't know if that's relating to a refusal to get vaccinated or not, Andrea. But Andrea also mentions that she's unionized and she works in healthcare and needs help. So I'll just touch on this comment because it has to do with a unionized employee. Andrea, we as a firm, we do not generally handle unionized matters. And I would ask that or suggest that you get into touch with your local union rep. As a unionized worker, you would also be subject to some form of a collective bargaining agreement. And that bargaining agreement should set out the process by which your particular situation would be handled. So, for example, you feel as though you're on a disciplinary leave of absence without justification, and you feel as though you're entitled, say, to compensation, then there will likely be a particular grievance process that's set out in your collective bargaining agreement. But again, I would touch base with your local union rep and see what they say. They should be, of course, your advocate in this scenario and give you some advice as to what kind of a case you have and what you're looking at. So I would definitely start there, and hopefully that can be of help. But thanks for your question nonetheless. Just going through some more questions. Razor Sharp on YouTube, he or she asks, how does an employee prove workplace discrimination when seeking the help of a lawyer? So if you're an employee and your case involves issues or allegations of workplace discrimination, ultimately it will come down to what evidence you have in support of that allegation. So for example, if something has been said to you verbally that is clearly discriminatory, you will have to ultimately prove that that was said. So I don't know if you've got potential witnesses who would have been within earshot, but otherwise it may just come down to your word versus the company's if they are disputing what was said. If you've got something in writing that suggests workplace discrimination, then obviously that can go a long way to helping you. It typically is quite rare for that to exist. But that could be another form of evidence that you would have to consider. And if it's a situation where you as an employee feel as though you were let go or terminated in some fashion for a discriminatory reason, say based on a disability or whatnot, then it would all sort of go back to how you can connect the loss of your employment to that disability or that protected ground under human rights legislation. So a lot of times discrimination cases can be quite tricky to prove, and unsurprisingly, they're often met with a response from the company that simply says, we deny that took place. So, appreciating that, you still don't want to necessarily leave any stone unturned. And that's something that if you find yourself in a situation where you've been subjected to discrimination, definitely something that should be considered and factored into and pursued as best possible. But that's generally how you would prove it. And if you need any further help, please give us a shout, and I'm sure one of the lawyers at our firm can help you. And I'll just take a point to say that we as a firm, we operate across the country at this point. So if you're someone who is facing an employment situation and you are living in Vancouver or British Columbia somewhere, we've got offices located there to help you. We've also got offices located in Alberta, Toronto, of course, where I practice, and Ottawa as well. So depending on where you're located or what your situation is, we've got associates and various lawyers and other support services available. And I would just ask you check out our website, stlawyers.ca, for more information on that. Going through some more questions. I've got a question from Shihas on YouTube. And the question is, what proves you don't consent to being put on a paid leave? After submitting a religious exemption that was denied and a leave of absence is issued. I think that if you're an employee or an individual and you're in a situation where you're being placed on a leave of absence without your consent, of course you can object to it verbally. But going back to the issue of evidence, you're going to want to think ahead and think about how you can potentially prove this at a later date if need be. And so if you're in a situation where you're rejecting this leave of absence, I would suggest putting it in writing, sending a message in writing to your employer that clearly says you do not consent to being put on that either unpaid leave or paid leave, because you believe it to be a significant change to the terms of your employment that you are not agreeable to. And I think that if you needed some more help in sort of massaging the message or phrasing it, you could definitely get in touch with us. We can potentially ghostwrite a letter for you or a statement for you so that it's clear on the record what your objection is. And later on, as I said, you could potentially use that to your advantage in the event that, for example, your employer tries to refute the idea that you refused to leave, or where the employer says that maybe you were silent and didn't raise any objection, and that should somehow constitute acceptance to the changes. So putting things in writing is always a good tip, pretty much regardless of what situation you're talking about. People don't typically think about putting things in writing because they don't expect or anticipate there being an issue later on. But you never really want to be in a situation where it's your word versus theirs, because that can always be tricky. And even if you are on the side of the truth, it could still nonetheless pose possible issues for a case. So putting it in writing definitely would be recommended. I've got some more questions. I've got a question from Seahorn on YouTube. They're asking if they need to use an airplane for a work trip, but they can't board because they're not vaccinated. Would they be entitled to severance if their employer terminates their employment? So what I would say to this is that if in order to do your job or the majority of your job, you're required to use an airplane, which by extension requires you to get vaccinated, and you cannot perform your job because of that fact, or the vast majority of your job because of that fact, then the question becomes, how can your employer accommodate you otherwise? So can your employer, for example, have you do your job without the use of an airplane? Because there's just going to be no way, at least at this point in time, that you can board that airplane if it's requiring a vaccination and you don't want to get it. So if that's the fact, or if that's the case, then the employer could say that they can't have you do that job, or there's no reasonable way for them to have you perform your job. So that's why I go back to, what other solutions can be thought of, what accommodations can be made, because I think the more accommodation that can be made, the more that your employer can sort of work out a solution in that situation, or the more that they should be able to do that, the more likely that you're going to be entitled to severance or greater severance in the event that your employer terminates your employment. Whereas if there is no realistic solution around it or accommodation at all possible, then that will be, I think, generally speaking, a leverage point for your employer to use. But to be honest with you, these things can come down to the very minute details. So I would say that if you're in a situation where it's maybe unclear, or there's a bit of a gray area, to get in touch with us, because it could be helpful to, for example, ask for accommodation in advance, just to kind of provide yourself with maybe some more leverage in the event that something happens later on. As long as, practically speaking, that is a feasible solution. So that's what I would say there, Seahorn. But otherwise, get in touch with us, and we can hopefully talk about it further and provide some further assistance. I've got a ton of questions, so apologies for those that I can't get to. But Spencer on Facebook, he's following up from his previous question rather, regarding him being laid off back in 2020, and if it's worth fighting over if he's worked there for just over a year. So in any situation where you as an employee are entitled to severance, there are likely going to be a number of factors that are relevant in terms of how much severance you can get. And the length of service is definitely one of them. Whether you signed a contract and sort of what that says on how much severance you're owed is another. And definitely employees with less time or a lower amount of tenure with the company are typically going to get less. However, there's just as good of a chance, Spencer, that you could get 3, 4, 5, 6 months of severance, depending on things like your age and the position you had with that company and how much you were earning. So if you're an employee with a relatively short amount of time of service, don't think necessarily that you therefore don't have a case, because there are definitely situations where short-term service employees tend to get disproportionately larger packages when, say, compared to someone with 15 or 20 years of service. So I would say, if anything, if you're still wondering, Spencer, to get in touch with us, and at the very least, we can give you a better idea of what you could be entitled to, and it could actually make sense to pursue it. So hopefully that answers your question. More questions coming in. So JD on Facebook is asking about being denied EI and asking me to speak to the options. So this is another good topic. Individuals being denied EI for their refusal to, let's say, get vaccinated, or because they're put on a leave of absence relating in some way to COVID. And it's a tricky thing, because as far as I understand right now, there are certain situations where employees are being denied EI. Now, that could be something that we could assist you with in trying to challenge EI's or Service Canada's determination on that front, because typically the only situation where you're to be denied EI is if you've either resigned from the company or if you've been terminated for just cause. And in order to be terminated for just cause, typically there has to be something quite egregious that happened, and maybe an issue with the trust or theft or ongoing performance issues. But suffice to say that the situations where you're denied EI are relatively slim, and for the most part, terminations or people who are even laid off or placed on a leave of absence should, generally speaking, be granted EI. JD, it may come down to you maybe explaining the context of your situation to them a bit more, and also come down to whether or not there's a particular mandate or piece of legislation in place, say, for example, requiring vaccinations. So it could be definitely contextual. But I would say that it's nonetheless something that should be raised, and you should pursue it. And if there's resistance on that front, then definitely you can reach out to us, and that may be very well something that we can assist you with in hopes of getting you some money in the short term at the very least. So hopefully that answers your question. And I'll answer one more question, but beyond that, I'll have to let you guys go. I've got a question from Cora on Facebook. Cora's been working almost 20 years with an employer, and she was put on leave with no pay, and is told after 90 days she's going to be terminated. So Cora, you've got a long time in there with that company. You're potentially entitled to a very significant severance package, in addition to possibly other damages or compensation. And regardless of whether or not you've been given 90 days, I think you need to contact us immediately. Again, better to get the ball rolling now rather than later. Get an idea of what your options are so that you're as protected as can be, and so that ultimately you get what's fair and owed to you based on those years of service. So Cora, get in touch with us, get some further information. There's some prompts at the bottom. You can visit pocketemploymentlawyer.ca, guys, if you want to find out some more information on some general questions that are often asked. Of course, you can contact us on our website, stlawyers.ca. And I will definitely be joining you guys at a later date. But on that note, I will let you all go. I thank you very much for all your time. And as you can see, we will be going live again 1 p.m. Wednesday of this week. So if anything, get in touch with us then, send your questions in, and we'll do everything we can to help out. But otherwise, do take care and enjoy the rest of your day. Thanks very much. Bye for now.